All persons that have any due before the Honorable Justice, the Appeals Court of Boston, draw near, give your attendance, and shall be heard. Rise in the Commonwealth of Massachusetts. This court is now open. Please be seated. Come on, everyone.
Morning.
Morning.
Whoa, this is way up high. For me. Good morning, and welcome to the Appeals Court session for March 2nd, 2023. I'm Greg Massing. To my right is Justice Hirschfang. To my left is Justice D'Angelo. And we'll be hearing a short list of 3 cases today. For anybody who hasn't been here before, the rules are very simple. 15 minutes per side, no rebuttal. We are familiar with your briefs, and so you can go right into your argument. You're free to use all your time, but you don't feel obligated to use it all. If you finish early, there's no penalty. In fact, it's kind of it's good. We have all of your materials on our tablets here, so if you see us looking away from you and at our tablets, don't worry. We're looking at case materials. We're not looking at the internet or stuff like that. And so I think that's it. First case today is 2022 P681, PM Zilioli versus Paul Zilioli, and another.
Good morning.
Just a sec, please.
Sure.
But good morning anyway.
Oh, good morning, yeah. Good morning.
Good morning. If I may?
Please.
So, Your Honors, good morning. My name is Howard D'Amico. I am counsel to the plaintiff and the appellant here. So, Your Honors, this is not a case that I tried. So this case comes to me on the appellate part of it, and what we did was, in preparing our appellate brief, we made 2 major arguments with regard to issues we believed that the trial court erred on at the trial court level. Those 2 issues are outlined in our appellate brief, and those issues, initially, the first issue is this question as to whether or not a previously agreed to jury instruction should have been rejected by the court, which it was rejected by the court.
So I don't see anywhere in the record where that previously agreed jury instruction is. Is it in the record?
I believe it's in the appendix record.
Yeah, can you give me a page reference?
I do not have a page reference. I apologize.
I don't think the requests for jury instructions are in the appendix. And in fact, I looked online at the submitted, I didn't see any requests for jury instructions online. I did see jury verdict slips submitted by both parties, and neither one mentioned anything about trebling the damages.
Prior to that, there was an agreement by counsel submitted to the trial judge to give an instruction that indicated that damages would be trebled.
So, I mean, there's lengthy discussion on the record. I know you weren't trial counsel. There's lengthy discussion about the jury instructions, about the verdict slips. At many junctures, the judge says, does anybody have any objections to this? Do you want to raise anything? Nobody says anything about the jury should get treble damages. I don't see how your issue is preserved. The issue that it should have gone to the jury.
I concede that at trial, at no point did plaintiff's counsel then object to the instruction that was given.
So why isn't it waived? Isn't the whole point of objecting on jury instructions to give the opportunity to a judge who, in this case especially, had many pages of jury instructions and may have just forgotten to give the one that was agreed to? When a party objects, it gives the judge a chance to fix a mistake. If there's no objection, isn't it waived for our purposes?
So there's a possibility that it's not waived to the extent the court, and then this court, can perceive that the underlying court did have familiarity with the plaintiff's desire to have the given instruction. Should there have been an actual objection to the instruction given, I concede there should have been. This court nonetheless has the ability to create from the record a determination that the underlying trial court nonetheless had the ability to understand that plaintiff, in issuing or looking to issue the agreed upon instruction, was otherwise looking to have that as the instruction.
I don't even, we don't even have the agreed upon instruction. I don't know how we can make that determination if we don't even have it in front of us anywhere. I'm not to say that we won't necessarily address your issue, because you raise it again in the remitter motion, right? I mean, you raised the legal issue whether the judge erred by not subtracting before the troubling.
It was brought up again in the remitter motion. That I can see those after the fact. So whether it's preserved there, I'll leave to the court. I think my initial argument is that it was sufficiently reserved prior to the instruction. I'll proceed from there.
Okay.
The second argument we make, I think, is a little more that argument that the damages themselves prior to being submitted to the jury and the slips should have nonetheless had direction that the damages the defendant was asking for should have been instructed and should have been crossed with the plaintiff's damages, offsetting first prior to then having the tripling of the damages. And so that argument's made. We bring that through in our brief, arguing that the court should have crossed the plaintiff's damages, single damages, with the defendant's single damages, and had an offset, and then whatever was left, if there was a net to the defendant's side, that then be trebled.
But, I mean, I see your argument, and from a math perspective, I can see how it would make sense, but the part that I find more challenging is the framework for awards of this type, Wage Act awards that are trebled, is based on a very strong policy reason that, you know, it's not to discourage employers, and I understand this was not sort of your typical employer-employee situation, but to discourage employers from taking advantage by trebling damages. Why is it an abuse of discretion for the judge to have done the math the way the judge did the math?
So, Your Honor, we've pointed to case law that suggests that where the party seeking the triple damages has also been a bad actor, that you can offset prior to the trebling. And so in this case, we think it was found by the jury that the defendant was in fact a bad actor.
But, I mean, taking you at your word, right, the cases say you can, they don't say you must. So why was it an abuse of discretion for the judge to do it the way the judge did it?
I think here the facts were so clear that this defendant came into court, that the jury saw and found that the defendant was a bad actor. The defendant had actually taken out on his own, paying himself as draws the same amounts of money he later claimed he didn't get paid as an employee wage earner. And so it is, our perception is it is an abuse of discretion.
How do you reconcile, how do you respond to their argument, which is that it's not that clear that the Wage Act violation was every week for 2.5 years, but the thefts came later?
With all respect, Your Honor, I think that the thefts came during the entire time of the defendant otherwise successfully arguing at trial that he was entitled to wages for the entire period he was employed.
But
Right?
that's your assumption. What we need to do, what you're asking us to do is say that that's what the jury found, and there's nothing to suggest that. The jury could have found exactly like Justice Massing just said, which was the theft was at the end as opposed to each week. We don't know, do we?
Well, I think we do.
How?
So I think the court would agree that the jury found that the failure to pay wages was throughout the term, correct? A certain weekly amount multiplied by a certain number of weeks. The math wasn't perfect, but you can draw that inference. The amounts that the defendant took were from the trial transcript taken out through the course. The events, and we have referenced that in the appendix, the amounts taken out. Now,
So let's start with one at a time. The one of them is a loan of, failure to repay a loan of $20,831. When did that happen?
That happened during the course of the employment.
Well, yeah, but I mean, I'm sorry, was it several different times, or was it was it a one-time loan?
It was one time.
So there's a date.
There's a date.
What date was that?
So that date is in the record, but it's clearly before the end of the employment.
But is it towards the end? I mean, yes, clearly it's all happened during the employment, but I mean, is it, was it, can you really put it together with to equate it with the wages?
Well, I think that you can. It's again, so I think what you're suggesting is if he hadn't yet earned the wages, then it can't be offset, but I could have a better argument if he had earned the wages and took them.
Okay.
Well,
I mean, actually, no, I see, I think you just answered, like, he doesn't know how much he was taken away until later.
well, and the two clearly from the record had a disagreement during the term as to whether he was going to be paid or not, and the jury found that he was. I can't get around that. So our argument is that the sequencing of the monies he took was during the pendency. Even if he took them late, they would still be monies that he took that would be offset by any argument he had that he was owed wages.
Okay, so but how do you answer Justice Hirschfang's question, which the essence of it was, this is a different kind of injury. Like the legislature has a particular policy about when you pay wages, but there's different policy about stealing and embezzlement and conversion and fraudulent misrepresentation, whatever.
Well, I concede that this statute is a high hill to climb, and I concede that its intention is to preclude employers from not paying wages. I think what I'm arguing is that there are clear exceptions to that where the employee has effectively resulted in self-help. And our argument is where this employee engaged in self-help.
So do you have a case where an employee has paid him or herself
Sure.
in lieu of actually getting payments, and then the judge has offset and said the law requires this, or where a court has said the law requires that this offset be done before the trebling of damages?
So I think the closest case I got, Your Honor, was this Mayhew case, which we've cited to in our brief. And in that case, yes, you had that fact pattern where the court found that the defendant had acted in bad faith, and the court believed that the trial court should have applied the offset prior to the tripling, prior to, in that case, application of a multiplier.
And that's from the Fifth Circuit.
It is.
So that's not interpreting the Massachusetts statutes.
When I'm at the Fifth Circuit, Your Honor, it suggests that I haven't found something.
It does, strongly.
I concede, Your Honor, at that point. So that is our argument. Those are the two arguments we've made.
Well, if you have nothing,
I wouldn't be penalized.
You're not.
No.
Thank you, Your Honor.
Thank you.
Thank you.
Good morning, Your Honors. May it please the court, my name is Attorney Paul Foley. I represent the appellee Paul Zilioli Jr. in this matter. I did represent Paul essentially from the beginning of this dispute in 2017 all the way up to my time in front of the court this morning. I'll address the issues as they were raised by my brother, but happy to jump around as the court is so inclined.
I'm glad you were trial counsel. I'm going to hit you right off. Do you agree that there was an agreement Again, I agree with Judge Massing. I couldn't find it either. But do you agree that both parties were willing to give the trebling of lost wages to the jury in a jury instruction?
I know that we had that in our proposed jury instruction. There was a trebling of damages instruction that we had proposed to the judge. To be honest with you, Your Honor, I think that was just, we drafted that out of a proposed jury instruction manual that we had. I don't believe that oddly enough, I don't believe that the plaintiff's proposed jury instruction had that kind of instruction in it. I'm also quite clear that there was no agreement between myself and the other counsel as to how the jury should be instructed on this.
But if you proposed it and they didn't disagree with it, and it was to their benefit, one could kind of say that was at least a meeting of the minds, if not an explicit agreement.
Yeah, I guess that I think in that question, there's the assumption that it would have been to the plaintiff's benefit to have that kind of instruction. I think that's an unknown question. It's just, from my reading of the cases that we've put before the court, in other circumstances, the court has made it quite clear that if you give that type of instruction to a jury, that it's deleterious to their deliberations. That the jury's job is to deliberate solely on the issue of damages, which is a factual question for the jury. It's then the judge's job to take that damages calculation and to render a judgment based upon the statutory law. So be as it may, whether or not my side proposed that instruction or not, I think that Judge Ricciardoni was correct in modifying that instruction and presenting it to the jury. I think the record is also incredibly clear. I find no reference from my brother's briefs that any sort of objection was rendered, that any sort of I think that the case law requires that the exact jury instruction not only be called out, but that the nature of the objection also be asserted at the time. It's sort of a super objection in a sort of way that has to be rendered for jury instructions. That wasn't done here, and I think it wasn't done because, from my vantage point, after the court proposed its jury instructions, I thought they were great in this respect, anyway.
Well, wait,
So-
hold on. You just, I don't want to say changed it.
Yep.
When you say the judge proposed instructions, do you mean what he actually gave the jury, or was there a discussion before it went to the jury of what he was going to do? And if so, were the treble damages in that?
My recollection, Your Honor, and I can't point to the record with respect to this, so I apologize if I'm misconstruing the facts. But my recollection is that we finished our trial evidence on a Friday. The judge asked us to send him electronic copies of each of our proposed jury instructions. He then took those over the weekend, and I believe on Monday, he gave us his proposed jury instructions. At some point in time during that period, I believe my brother and I both had the opportunity to review those jury instructions, and ultimately, we both assented to the judge's jury instructions.
So in the Record Appendix, Volume 12, it begins with an excerpt of a trial transcript from October 18th, 2021. It starts in the middle of a paragraph, but it appears, just on a quick reading, to be the judge running through proposed jury instructions, and then the parties weighing in. You say, Your Honor, can I be heard? The court says you're going to talk about shareholder. There was a back and forth. And then the judge goes through what reads like proposed instructions. Again, I don't have the framework because we don't have the beginning. And
Actually, I think these are the
that may be the instructions. I'm sorry.
The actual
Yeah.
instructions.
Judge Hirschfang, I think actually, but it brings up another point, which is actually during the judge's charge, I did object to a portion of the instructions because there was an error in terms of how he was referring to shareholders versus officers.
Yes.
And I corrected him on that. He corrected the record to the jury. So I think it's actually a good foil for what we're talking about here, which is I made a timely objection. I enunciated to the court what the nature of that objection was, and the court revised itself accordingly. No such thing was done by my brother counsel at the trial. It is still my recollection, to answer your question, that we were given the proposed jury instructions from the court, given an opportunity to review them, given an opportunity to object, and I think that a closer reading of that transcript would bear that out. But I apologize, Your Honor, I don't have those.
And I'm sorry to belabor this point.
Sure.
In the proposed instructions that the judge gave you in writing, Were the treble damages in there or not in there?
They were not.
So what he gave you is what he read?
Correct.
Okay.
Yep.
Thank you.
Yep.
Can I direct you to more to the merits now? I guess in terms of the remitter, and I'm asking you a question, and I know your answer is going to be it doesn't matter on the facts of this case. But and I'll give you a chance to say that. But before you say that, is it fair to characterize what your client did as stealing money to pay himself for missing compensation?
I would say, Your Honor, that it's not fair. First off, it's from my own personal view of the case, it's just simply not what happened.
Well, so what happened?
From my vantage point, Your Honor, and I know that we're going off record here, but from my vantage point.
Well, no, I want on the record on what the evidence was at trial.
The evidence at trial was that Peter Zilioli signed every single one of these checks. There wasn't some sort of situation where my client, Paul Zilioli, was drafting checks to himself and signing them himself or defrauding the company. He was asked by his brother to prepare checks for payment to vendors and for other payments. He prepared those checks. Those checks were then presented to Peter Zilioli. On every single occasion, Peter Zilioli signed those checks. In addition, Peter Zilioli had access to all of the bank records and, in fact, received them on a monthly basis with the canceled checks that he had signed.
Okay, so I mean, and the jury's determination was basically that Paul got Peter to sign those under false pretenses, and therefore, was he just stealing, or was he saying I'm owed money and I've got to figure out a way to get it?
If you look at my client's testimony, Your Honor, he's saying that there are certain checks in which he's recouping money that are out-of-pocket expenses. So not compensation per se, but he went out and bought pumps for the company, or he went out and did something else for the company, and he was taking a recoupment of payment on that. Another check, Your Honor, a $15,000 check that was issued to his father from the company. His father's name is also Paul Zilioli Sr. My client's summary of the facts is that upon being given that check, his father said, I don't want the check. Why don't I just give it to Paul? And he gave him the check. So there's another $15,000 there that my client says was just a flat-out gift. I apologize to Your Honor, because I don't have an exact summary of what my client would say was quote-unquote compensation versus what were these other miscellaneous payments that he received. I would say that there is some amount of money that my client, on the record, indicates that he was being given as part of his compensation package. That comes through actually in some of the excerpts that I presented to the court. Be that as it may, Your Honor, that's not what the jury found. And I think what I was struck by in terms of reviewing the record for today were two of the special verdict slips. And I'll just refer to, I believe these are Appendix 13, page 18. These are the plaintiff's special verdict slips. And I'm summarizing here, but special verdict questions Q1B and Q3C both seem to indicate that the jury found that, in fact, my client, Paul Zilioli, was not paying himself from the company for wages that he was owed. I leave it to the court to read those themselves. I don't want to misconstrue them, but I was struck by those findings today as I was kind of re-reviewing the verdict.
So which ones in particular?
I'm sorry?
Which ones in particular?
Q1B and Q3C.
The Q1B is, do you find that Paul took money in excess of his agreement? And it's yes? No, it's no. Okay. And then the other one was? They had yes and they crossed it out. And then Q3C.
3C. I do.
3C.
I don't want to fumble around my records here. But.
Was it Paul's misappropriation of company money the fruits of a contract? No.
So if it's okay with the court, I do want to get to what I think is sort of the more substantive issue in terms of how it is that we're supposed to consider this carve-out, essentially, that I think Peter Zilioli is advocating for.
Right. This is the part where you say it doesn't matter whether he was taking it for compensation for himself or not.
I was thinking about this today, and I was thinking of different hypotheticals that the court might throw at me. And I think there are hypotheticals that I would struggle with, but this case is not one of them. I think the facts show that my client was hired in June of 2015. He was not paid a single dime until September of 2015. It's not disputed in the record that during that entire time period, Peter Zilioli was not only calling in the payroll, he was also, as he was throughout the entire relationship, cutting all the checks. He was 100% in control of payroll during that entire time period and never paid his employee a single dime. That's the facts of this case. That's essentially the setup for what happened going forward. My client was getting stiffed. His brother at the same time is building a $800,000 home in Hopkinton and raiding the company coffers to fund that. This is what I tried to pound into the jury on my cross-examination of Peter Zilioli. And in spite of all that, my client is not getting paid. So this is not a hypothetical that I think.
That's June through September of the first year?
17.
June 1 of 2015, correct. Yep. So I don't think that this is a hypothetical that engenders any sort of sympathy toward Peter Zilioli, but more importantly, I don't think that it in any way qualifies him for any sort of safe harbor or cutout from the Massachusetts Wage Act. I think the Wage Act is really, really very clear. And if it's okay with the court, I just want to read, I think the case of Reuter versus Methuen has some pretty excellent excerpts from it. This is 489 Mass 465. And in this case, the employee was owed some sum of money for vacation pay. She wasn't paid it when she was terminated. It was about $9,000. The employer then subsequently paid her the vacation pay, but the court ultimately found that because they didn't pay it on the day she was owed it, triple damages, attorney's fees, on the $9,000 she was owed. The court, in looking at that issue, although it seemed to note the equities involved and how the court may have had some sympathy for the employer, it indicated this is page 473, the sentence at issue is also preceded by a sentence that directly addresses defenses generally, stating, quote, "No defense for failure to pay as required shall be valid," close quotes. And so in this case, there is no defense. The only defenses are the statutory defenses, and those defenses are the valid setoffs. Those valid setoffs, just to be clear, I'm sure the court's aware of these, but I'll just read them into the record, are trustee process, a valid assignment by the employee, a valid setoff, which I'll get to, absence of employee at the time of the payment, and a tender of payment to the employee. None of these carve-outs from the Wage Act apply in this case. Again, the framework is there is no defense. There are some cutouts, and one of them is a valid setoff. A valid setoff is pretty strictly construed by all of the case law. It is an agreement between the employer and the employee that a certain sum of money is owed to the employee. So for example, if at the beginning or some period in time during the employment relationship, the employer loans $5,000 to the employee to buy a car. They enter into a contract that says you owe me $5,000, I'm going to take this from your wages. The employee signs it, the employer signs it, valid setoff. That's that case. This case is not a valid setoff, and I would say that if the court is going to consider it to be a valid setoff, that we are starting down, and I hate to use these words because I know they're very cliche, we're starting down a pretty slippery slope in terms of when employers may or may not pay their employee. My brother says, my client was a bad actor. I'm assuming 90% of employers in a situation where an employee has left employment are going to call their employee a bad actor. So, it's almost inconceivable that there won't be a flurry of cases trying to assert this cutout.
Okay, I think we get it, and your time is expired.
Thank you, Your Honor.
Thank you very much.
Thank you.
So interesting case. We'll take it under advisement.
Thank you.
And next case is Commonwealth versus Jovino Rivera, 22P923.
Good morning, Your Honors. Philip Wepper representing Mr. Jovino Rivera. Mr. Rivera's case is here today as the motion for required finding should have been granted. As Your Honors are aware, in order for Mr. Rivera to be convicted, the Commonwealth was required to prove that he possessed a gun that was capable of firing. As such, they were required to prove that he possessed the gun that was found in the grill. Anything else, they would be insufficient to show he was capable of firing. Now, this was problematic for numerous reasons. The one witness that testified at trial testified that Mr. Rivera, she saw Mr. Rivera with a gun. However, she testified that it was a gun with a silver muzzle, while the gun found in the grill is a gun with a black muzzle.
Counsel, maybe I missed it in the record, but did the prosecutor or the defense lawyer ever actually show the gun to the witness or a picture of the gun?
I'm not certain if the exact gun itself was shown to the witness. I don't.
What about a picture? I couldn't find that either.
I don't believe that a picture of a gun was shown, but she was certainly asked numerous times, are you sure about the color? She was given chances to maybe say, oh, I'm not sure, but she was asked more than once, like, are you certain about the color? And she testified with no uncertainty that she testified that it had a silver muzzle. Now, guns don't come in exactly a ton of varieties. I know that with some exceptions of novelty guns, generally speaking, silver and black are the two colors. So we're talking about the two general colors guns come in, and she describes the wrong color. This is not at all some minor detail. This is quite significant.
But why isn't that a question of fact for the jury? The jury weighed, it was clear in the transcript of what her description was. Again, I don't think a picture was shown or anything. But then the officer testified to what he actually found. And isn't it up to the jury to decide whether that's the same gun or not? How do we step in and change that?
I would argue this because, in any issue of required finding, there's always that question of, well, why couldn't the jury have decided with any issue where there's required finding? Why couldn't a jury have found that this was sufficient? That's why the motion for required finding exists, because otherwise we would, if we're always going to say that it's up to a jury to decide, then there's no purpose for a motion for required finding. The whole purpose is that the evidence presented is insufficient and that a jury shouldn't be even given that opportunity because there's been insufficient evidence presented, as is the situation in this case. Because without that gun, ultimately, and the Commonwealth at one point tries to argue that it's an issue of credibility, but this is not an issue of credibility. I am indeed giving this witness all the credibility that possible, but ultimately, even with 100% credibility, she describes a different gun than the one that is found in the grill.
Well, I'm just not sure that's fair. She describes a gun with a wooden handle that is in a black holster that is being held by someone who is on the street. She's on the second floor in a window. Is your contention that we should supplant the jury's determination because it's not possible that the light shining off the muzzle portion of the gun, for example, made it appear silver to her?
I'm not even aware if there's any testimony about light shining off of it. I don't see how light shining off of a gun is going to change it from black to silver. I feel as though that would be a rather large leap to be made. Ultimately, either way you look at it, there's either the possibility that due to the fact that it was nighttime, due to where she was standing, that she doesn't have a good view. Now, if she doesn't have a good view, then that calls her entire testimony into question. We're either to assume that she definitely saw the gun, and if she definitely saw the gun, her description is incorrect, or she didn't have a good view of the gun, she didn't necessarily see it accurately, which, again, would completely call into question her testimony, because if she doesn't have a good view, that, again, completely would call her testimony into question. So either way, it's...
So I guess I'm going to have to apologize for quoting Meatloaf during oral argument, but is this not a 2 out of 3 ain't bad situation that the jury could have determined, look, there's a gun in a grill in an area between two buildings where she saw a man carrying a gun walk and then walk back from. The gun in the grill is in a black holster. It has a wooden handle. Why is that not a jury determination?
Well, one correction I'd like to make, Your Honor, is she actually never testified about Mr. Rivera walking towards the grill. She testifies about him having a gun in his hand, gesturing with it, but never actually, there's actually nothing, no testimony or any evidence otherwise that establishes that he went towards the grill and then
Didn't she
back.
testify, that he went between the yellow house and the blue house?
I don't recall the exact wording of her testimony, Your Honor, so I apologize if I'm missing something, but my recollection is that she testified about him having a gun, and she described the general area that he was in when he has the gun, but I don't recall any testimony that establishes him next to or going towards the grill. And I will admit that I don't remember the exact wording of the testimony, but I certainly don't recall any testimony that establishes that much. And in regards to the rest of Your Honor's questions, her description is not exactly some incredibly specific description either. If this was some scenario where she talks about the exact make and model of the gun, what type it is, but the one thing she got wrong was the color, maybe then we'd be dealing with a different circumstance, but that's not what we're dealing with here. Her description of the gun is a very vague general description of, well, just about any gun. I mean, not every gun in the world has a wooden handle, but that's not exactly some rare description. I mean, describing a silver gun with a wooden handle and a black holster, if you ask a random person to describe a gun in general, that might be the description they give. So this is not some incredibly specific, particularized description.
There's one place where she says it's an old school revolver with a long barrel. That's a pretty good description.
There's
a picture of it in the record.
And thank you, Your Honor, for having the exact description. But again, even that description, an old school revolver is with a long barrel, I would argue that that's not an incredibly specific description. It is, I mean, a revolver is, I'm no gun expert myself, so I'm not sure exactly how many types of guns there are, but revolver is one of the few types that I would be able to name, in fact. So when we have a description like that, I think color, when again, there are, for the most part, two colors that guns come in, I would say that is an incredibly significant detail, significant enough that it does indeed call into question whether the gun she saw is the same one found in the grill. Because again, I am giving, under the Lattimore standard as is required, I'm giving all deference and due respect, so I am going under the assumption that she did see a gun. I'm not saying that I'm not trying to claim she made up anything, I'm not trying to claim she's lying. Doing this under the light of the Lattimore standard would be a finding that she saw a gun. But as Your Honors are aware, that's not sufficient for a conviction that she saw a gun. It would be required that she actually saw that the gun in the grill, or at least required that that Mr. Rivera be linked to the gun in the grill. And her description, that error in the description of the color is, I would argue, significant enough that it's not enough to link him to the gun in the grill. And outside of her testimony, there's obviously the other factors the Commonwealth argues links Mr. Rivera to the gun in the grill, but I would argue that those are as well insufficient. There was no DNA evidence that says that Mr. Rivera had touched that gun, no fingerprints on either the gun or the grill, nothing specific that says that.
Counsel, I want to make sure I understand this. Are you conceding that the eyewitness observed a gun and that your client had a gun, it's just not that it's that gun that's in the grill?
I believe under the Lattimore standard that, I mean, I'm not conceding that specifically with regards to my client, but I would argue that under the Lattimore standard, Your Honors would be required to credit her testimony, and if you're required to credit her testimony, then you would therefore be required to credit that she saw a gun.
I appreciate that. So don't you think that based on those fair inferences from the transcript or from her testimony, the gun is in an area, I won't say directly where the defendant went because maybe that's missing, but certainly an inference that it's near where your client was. So you have defendant, your client has a gun, he goes to an area where a gun is found. You don't think it's a fair inference from those two things that the jury could say, she got the description wrong, but that's the gun?
I would argue no, that is, I think that's going a step too far because, again, this is a description of a gun. This is not just a question of, I think this is one of the reasons why motion for required finding is so important in this case, because I think a jury would be tempted to make such an inference.
What if the witness had just testified he had a gun
and
didn't give a description? Would there then be enough?
Well, that would be a different, if she didn't give an erroneous, if she didn't, that is a scenario where she did not give an erroneous description of a gun. If she didn't give an erroneous description of a gun, that would be a different scenario, but of course, that's not the scenario here. If the description would have been more broad, there are questions, I mean, then it would depend on exactly how the testimony came out. Then I would almost argue there'd be ineffective assistance if a defense counsel doesn't ask, what does the gun look like? If no one ever asks what a gun looked like, that couldn't, and I would argue ineffective assistance. But since that's not what happened here, and since trial counsel did in fact make a big an issue out of the color of the gun. I mean, trial counsel did very much stress that issue in the trial. And in fact, I do think this is why required finding is such an important thing, because I think there is the question that the jury might make that leap, but that leap is not what is legally permissible in this case, as the Commonwealth is required to have that sufficient evidence that shows that he possessed the gun in the grill specifically, when I think a jury might be tempted to go, oh, well, maybe he didn't possess the gun that was found in the grill, but if he had a gun, close enough. A jury might be tempted to do that, but close enough, as your honors are aware, is not what we are here about. We are here about legally sufficient, not about a jury maybe splitting the difference and compromising on things. That's very much why a required finding motion here is such an important issue.
But I guess, I mean, that brings me back to Meatloaf, right? Because, you know, I'm talking about the musical artist and not the questionable dinner. Okay, so, you know, the jury is presented with the witness who testifies. It's the jury's province to determine whether she's credible or not. The jury is presented with, at least the jury has a picture of the gun. The witness doesn't appear to have been shown a picture of the gun. And the jury has a description from the witness of what she saw in terms of movement of the defendant. Why is our job to say that the jury was not permitted to conclude under the facts that were before it that this witness is credible? She described with particularity an item that is substantially consistent with the thing that was found in the grill. The timing works. We know she saw something. Maybe she got the color of the barrel wrong, but otherwise she gave an accurate description. Why is that not their job?
Well, I would argue that it opens a door into problems that I think a jury would be likely to make. I mean, I think it's the same reason that we don't allow juries to hear evidence from illegal searches, because a jury might think, oh, well, maybe a cop didn't get the warrant the way they should have, but who cares? The guy still had the drugs on him. I think there's a comparable situation out here. It's, oh, well, maybe the cops didn't find the actual gun that was used in the commission of this offense, but, you know, there's testimony that this guy had a gun, and we still want to convict him if he had a gun, even if they didn't find the actual gun itself. I think a jury would tend to compromise in that way and think, well, if there's a gun, who cares if they found the exact gun? We got this guy had a gun, that's good enough for us. And I think that's the issue that we have here, and that's the reason why I think a motion for required finding should be granted, because jurors, I mean, it's understandable why a juror might do that, but just because they have that thought process doesn't mean they should be allowed to do that. And that indeed is the problem here. I mean, there is a reason that the standards exist the way they do, because, again, we don't know if the gun that Mr. Rivera, the testimony would certainly had, we don't know if that gun was actually capable of firing or not. That very much would have been a live issue at trial, but if that gun is not recovered, we don't have that chance here. And then therefore we have the situation that we're in now, where a jury decides they might want to compromise on the situation. They might decide they think it's close enough, when close enough is not close enough, when the case law and the standards do show that it would actually have to go farther than that. Because indeed, and I will certainly state that the issue of the witness description is rather significant. It probably is the central part of it, because once you get past that, there isn't enough to link Mr. Rivera to the gun that is indeed found in the grill. I mean, the only evidence the Commonwealth was able to present is that he showed some opposition to the police going towards that driveway. But in fact, even then, the testimony, in fact, at trial even states that, I don't want to say he was nervous, an officer testifying, but apprehensive. So he didn't even show that he was nervous about them going there, more so that he was annoyed. And while I would further expound on that, seeing I have about 5 seconds left, unless Your Honor have any specific questions, I rest on the arguments presented in my written brief.
No, thank you.
Thank you.
Good morning. May it please the court, Kristen Jing for the Commonwealth. Here, as I stated in my brief, there was ample evidence to support the indictments here. I do want to point the court's attention towards, one, the firearm and the holster were admitted as exhibits into evidence. The site is the second volume of the trial transcript at 111. Also, in my supplemental appendix, I presented 2 pictures of the firearm.
Was the witness asked to look at the firearm, or?
No, I don't believe she was, no. She wasn't, but the jury could compare the witness's description as, a silver firearm with the pictures and the firearm itself. And you can see from the pictures that while it was black, it was metallic. And you can look at the time of day that this occurred, and the jury could very well have made the inference that she was just mistaken about the color, that it was silver. There was also absolutely evidence that the witness testified that she saw the defendant walking towards the area of the grill. It's actually captured on the 911 call that was admitted to the evidence that I also submitted to the court. It's at trial.
She doesn't mention the grill in the 911 call.
She doesn't mention the grill. No, she never mentions the grill because she can't see that far, but she says that she could see the defendant walking towards the house number. She actually mentions the house number in between the 2 houses. And she also testifies to that at trial volume 2 at 42 and 45. So taking those 2 together, along with evidence from the police officers about the defendant's behavior on the scene when they started walking towards the area of the grill, saying, hey, you can't go there, that's private property. By the way, he didn't live in either of those 2 houses. So taking all that together, the jury very well could have made the inference that it was, one, that he was holding a gun in the street.
Can I ask you one question? You mentioned he didn't live in either of the 2 houses. Was there affirmative evidence that he didn't live in those 2 houses, as opposed to he didn't establish that he lived in those houses?
I believe that there was, and I believe I pointed that out in my brief, but I could see. I know that there was evidence that the police talked to the owner of one of the houses where the gas grill was, and I believe that one of the police officers testified that he did not live in one of those houses. But I can double check that. And I'm sorry, I'm not finding it quickly, but I do know that I mentioned that in my brief. I believe one of the police officers testified to that.
You said it's 2101? The defendant didn't.
Yes, there we go. So that must have been the testimony of one of the police officers, that he didn't live in either of those 2 houses. So there would be no real reason for him to have that sort of reaction. And again, it's just information for the jury that they can draw inferences from. And if there are no further questions, I'm happy to rest on my brief.
Nope.
Thank you very much.
Thank you. We'll take it. The case is submitted. That sounds better, doesn't it, than taking the case is submitted. And we'll hear the last case for this morning, which is Department of Children and Families versus Mother and Father. 22P502. And as you get up here, I understand you're both splitting your time 50-50, so 7.5 minutes each?
Yes, Your Honor. Yes, Your Honor.
Okay. And as this is an impounded case, please make every effort not to refer to anybody by name, especially, the parents or the children, refer, mother, father, older child, younger child.
Yes, Your Honor. Thank you, Your Honors. May it please the court, my name is Lucas Newbill. I represent the appellant father.
To state that this case is an aberration is an understatement, and that was acknowledged by the trial court judge in this case when on the record he stated, nobody could have imagined that we would be here.
Well, I'm going to go right at it. It's an aberration in the sense of how much time elapsed. However, it's not an aberration that judges often will withhold a decree until after the guardianship hearing. Is that correct?
That is absolutely correct.
So my issue or question for both you and your sister counsel is, how long is too long?
So, I'm not arguing for a bright line here, and I'm not arguing to change the practice of juvenile court. This is not the practice of juvenile court. And that a year passes between an agreement to limit issues at trial and the trial actually happening, and in the meantime, a motion is filed, which in sum and substance is a review and redetermination, which a parent has a statutory right to file.
Okay, let's characterize what the stipulation was. I mean, at the time of stipulation, the parties said they're not contesting fitness or termination.
Yes, sir.
And they agreed that the evidence was this packet of evidence, right? So basically the case was, went to the judge on basically a case stated sort of basis. There wasn't going to be a trial.
So, Your Honor, in a Section 3 termination, voluntary termination, parents can agree to unfitness. There can be an agreement for judgment, but it's not a contract case. The parties can't agree for judgment, and that's it. The judge has to make a determination that termination is in the best interest.
Right. Well, I mean, and in this case, I mean, the judge's findings, for a case that the parties stipulate, the findings are extraordinary in terms of their detail and the amount that the judge went into it. And I don't see the judge actually even relying on the stipulation.
Well, so he relied on the stipulation in order to deny...
To not have a trial.
In order to deny the trial, right? And...
Which that means basically, wasn't it basically a waiver of the trial at that point?
So it was an agreement to limit the issues at trial, and material to that agreement was that judgment would enter forthwith. That's not a tacit agreement, that's in the agreement. Judgment shall enter, the judge shall enter the decree forthwith.
Well, I'm going to go back to my question, kind of. What does forthwith mean?
In this case, trial was set for 2 months. That's the tacit agreement. The way that these cases work, they're resolved within 1 to 2 months. Douglas, 17 days. The appellees have put forward no case to show, and it doesn't happen.
And you haven't
because pandemics don't happen.
To the best of my reading of the briefs, neither you nor sister counsel have put forth any case where a stipulation has been allowed to be withdrawn in such a situation.
I don't believe there are any cases where a stipulation was attempted to be withdrawn before the decree entered. In fact, there are none. All of the cases, Malik, Dora, everything before, that's post-decree or post-trial motions. And that's why the standard is quoted by the appellees is incorrect. The motion for trial was not a post-trial motion. There had not been a trial. There had not been a decree. And the judge used the wrong standard. The judge only wanted to know whether or not the agreement was knowing and voluntary. And that's correct under Nate, which was a year after the decree, the judge vacated a decree a year after it was issued. It's correct in surrender of minor child. There we were dealing with a Section 2 surrender, a completely different situation. That's not an involuntary termination under Section 3. You can't withdraw that. It's written in the statutory language, which it has to be strictly construed that this is irrevocable, which was nowhere to be found on this agreement. It's not like Scott, which was a motion filed after the decree issued. The proper standard and the proper case is Douglas. And in footnote 6, page 125 of Douglas, which is 473 Mass 1024, although detailed written findings are not required when a parent has consented to the entry of a decree terminating his or her parental rights, a judge nonetheless must determine that the stipulation was knowing and voluntary, that the parent is currently unfit, and that termination is in the child's best interest. And he completely disregarded those two factors, those two considerations when denying that motion, and he erred in doing so. These cases resolve within a month or 2 months. Douglas is 17 days. The judge acknowledged nobody could have imagined. What would it have cost in a redetermination hearing to determine the current needs of the children? You start from the determination. In this case, it would be the agreement, right? So what would it have cost? 1 day, 2 days, tops of testimony to say, hey, this is the progress that these parents have made in the past year. Why not hear that?
So wait a second. The parents stipulated to unfitness on March 12th, 2020.
Right, Your Honor.
And I take it after that, the department's done with them, right? There's no more action plan. There's no more checking in. There's no more visits. What evidence could there possibly be? I mean, how is DCF going to be able to, this one-day trial? What evidence is there?
Oh,
Which you don't, which in your motion to withdraw, of course, there's no reference to any evidence. It's a change of heart. And yeah, we're better now.
Well, it's not just a change of heart. The attorney for father made an offer of proof that the circumstances have changed during the
he didn't make an offer of proof. He made a statement that the circumstances have changed.
He labeled it an offer of proof, and the judge didn't want to hear what those changed circumstances was.
Was that at the hearing?
That was at the hearing for the motion for full trial. So the dad was denied the opportunity to present the changes that he and mother had made. And it's important to remember, when we look at these cases, these cases change throughout the trial.
But the stipulation was unfitness indefinitely. That's what the stipulation was. I don't see any difference between this and any stipulation, and then 2 years later, mom or dad has done remarkably well. They've gone to therapy, they've changed their ways. In that type of circumstance, you don't allow a mother or father to come back in and say, hey, you know what? We've changed our minds, we're doing better now, we want the kids back.
But the stipulation did not contain the language that they were unfit indefinitely. The
Agreement did.
From what I read, it's likely to continue into the future, right?
Sorry.
And that's important. Why is that important? Because future parental fitness, you go into Carlos, a judge has to look at the capacity for the parent to change and be a better parent. We're talking about termination, fundamental rights, and my time is up.
Thank you.
Thank you, Your Honors.
Good morning, Your Honors. May it please the Court. My name is Joan Altamore, and I was appointed to represent the interests of the mother in this case. Your Honor, I am a practitioner at the trial level in care and protection cases. And what we first have to address with the Court, the first argument, is that the delay caused by the COVID-19 pandemic caused mother's stipulation for judgment to be stale and no longer in the best interests of the children. The second argument is that the passage of 13 months and the best interests of the children required the court to inquire whether mother agreed she's still fit. Your Honor had questions for my brother counsel about whether or not it was their unfitness could continue or was likely to continue. That is the phrasing that is in the judgment. But the court, when the parents filed their motion, the court discussed Caesar. And in Caesar, this court said, or the appeals court said, that the judge erred in refusing to reassess on the basis of material post-trial developments the question of whether or not the termination of mother's parental rights in the then current circumstances would serve Caesar's interest. Another case would also be Douglas, in that until the parental rights have actually been terminated, the parents still have a right to participate in the proceedings. In this case, there was an agreement between all parties that no decree should enter until the conclusion of the actual trial. And that was going to be a guardianship trial, and mother and father were allowed to present their guardianship person, and the department and the children's counsel.
Can I ask you about that? The agreement that no decree shall enter, is that, where is that in the record? Was it a testimony? Is it a document?
It's documented. It's in, I don't have the actual citation for you, Your Honor, but when the parents entered into their stipulation, there is notation in the record from the judge and concurred by all counsel that no decree should issue. It is clear case law that once a decree issues, the parents have no right to participate further in the hearings, that they're essentially then shunted to the side. Drawing to Your Honor's question.
So can I ask you about that? So, I mean, Attorney Mazzoni says that that's a case then of no good deed going unpunished. That the judge, as a favor to to keep the parents standing, the judge says, I will withhold this.
It's a negotiation, Your Honor. What incentive would it be for the parents to sign a stipulation if they were then shunted to the side? Drawing one of Your Honor's questions to my brother counsel, how do we determine unfitness? First, let's focus on the findings entered by the judge. Stop. There is no finding entered against either parent after March 10th, 2020.
That's because there's no evidence presented.
There is no evidence presented, exactly, Your Honor. We are asking that, but that then becomes stale evidence.
Okay, so now I'm going to go back to what Justice Massing asked your brother. So let's play this out. He said, oh, just another 1 or 2 days. That's not accurate, because what would have happened is the department would have maybe by stipulation presented all of the evidence up until March 20th. You would have presented mom and dad's evidence, and you would potentially be here arguing that all of the evidence they presented was stale because they had nothing between 2021 and the time of trial.
Your Honor, in actuality, the department does not cease operating the case. The department, with no decree having entered, still has an obligation under the action plan presented to the parents to visit the parents on a monthly basis. They have an ongoing obligation. We don't have the evidence because no evidence was taken in this case. There is no testimony from either parent. There is no inquiry from either parent. There is nothing for the judge to assess whether or not there has been a change in circumstance. In fact, and that's where Caesar comes in. There was it wasn't actually Caesar. It was adoption of Rona, in that the court said the passage of substantial time. So mothers, in that case, the judge had terminated mother's parental rights and said that, it was overturned because the court found that mother's drug use 4 years prior was the basis for the termination of parental right. And the judge should have evaluated what mother had done in the next 4 years. Rona was also because another reason for its remand, which is what we are asking for here, is that the judge took more than a year to issue his findings. The appeals court said, you need to go back and reassess what has been done during that period of time, because until the case is actually closed, and closed means the guardianship is finalized or the adoption is finalized. And in Rona, it was about an adoption. Until then, there is an obligation by DCF to continue meeting with the parents, having contact with parents as well as with the children.
Counsel, let me ask you something, maybe outside the record, but is there any way that you can think of outside of withholding the decree that would allow a mother and a father to have a say in a guardianship proceeding?
No.
No?
No.
What about an agreement that a motion to intervene would be allowed and that mother and father would be allowed to participate? Because the problem I have with this case, which you've raised very well, and your brothers are going to have an opportunity to get a preview, is if the judge had entered the decree that day, this case is over and we wouldn't be seeing you. It was the problem that the judge followed Malik, which maybe isn't a good idea.
But, Your Honor, I think based on the fact that this is not whether somebody's going to serve a criminal sentence for a period of 1 month, 1 year, 10 years, even saying a life sentence, because they potentially have the possibility of parole. You're looking at a termination of parental rights. Termination of parental rights. People have a constitutional right to raise their children. By giving up that right, by signing that stipulation, they're taking a big step. The agreement was that they could have a say, these parents could have a say in what their children's future was going to look like. There are cases, and if a motion to intervene is probably a higher standard, because you have cases where the parents' rights have been terminated, they get adopted, and then the adoption fails. That parent has to come back not as a parent. They are no longer a kin in those cases. The decree, giving them the ability to hold off the decree, allows these parents to have a say in their children's rights.
Am I right that the record, and I think this is in the record, that the guardianship was ultimately awarded to paternal grandparents?
No, and my time is up, Your Honor, but just to answer your question, it's my understanding that the guardianship was given to the paternal stepmother. So there was actually no kin relationship between she and the children.
Parents, and I'm sorry for going over, parents' proposed guardian withdrew the application. So there was no one left, correct?
Ultimately, after testimony, that application was withdrawn, but there's no
Is it
testimony.
after testimony or?
Yes, that the parents proposed, I believe, if my recollection of the record is correct, is that person did testify, and then it was withdrawn. And noting, Your Honor, that trial did not happen for another 3 months. More time for the case to get stale, for the evidence to be stale. Thank you.
Thank you.
Good morning, Your Honors. Justice Massing, may it please the Court, Dean Mazzoni, Assistant Attorney General, on the Department's behalf. Absent any direction from this Court, I'll attempt to address the issues in the order that my learned sister and brother did. But I'd like to preface it by saying Your Honors have hit on all the main points in this case. The Commonwealth is unaware, has looked for, has found no case where an agreement for judgment, stipulation to unfitness has been unwound or been allowed to be unwound for changed circumstances. Adoption of John is on point and dispositive of this case. Respectfully, Justice Massing, you were kind enough to quote language I used in my brief, which is that no good deed goes unpunished. This judge was scrupulous, was careful. He knew the facts and he knew the law. And he, frankly, was mindful and was considerate of the concerns that my sister just outlined so eloquently that a parent has for their children, where the facts of the circumstances of the conduct of the parents towards the children is uncontested. I won't go into them here. And Your Honor, I'm sure, is well aware of the facts, which are not pleasant. Those facts are uncontested below and are uncontested here. Nevertheless, after, to their credit, admitting to the facts, the court, he knew Malik very well, it's quite clear, he cited the case and said, I want to give these parents an opportunity to participate in the competing plans portion of the case.
Other than withholding the decree, can you think of another way that a judge can allow the parents to be heard at the guardianship hearing?
I'm unaware of any published case, but I suppose you could put it you could fashion an agreement, I think. You know, I don't see what would prohibit it, so that's, I think, Your Honor is right on point, as you've been with a number of things. I think you could put it in the agreement if you wanted to. But again, the judge was cognizant of the case law and knew that if he immediately entered the decree, that these parents would not be able to participate to the extent they could in the future of their children. And
What do you say to the fact that the statutory language in Section 3 requires current unfitness, and the fact that all of the facts on which the judge made his ruling, I think 3 months after the motion was filed, were by that point over a year old.
It jumps out at you in this case, Your Honor, your question. I think current unfitness, when it's stipulated, again, you have to go back to adoption of John, and as the trial judge said below, and as my brother said, it could take months for a completing plans portion of the case to be finalized after an agreed stipulation. 3 months, 4 months, 6 months, 13 months, COVID, it happened. But I think the question is, you have to look towards adoption of John. Current unfitness was uncontested, determined authoritatively by the judge at that time. I think to the extent that, when the competing plans portion, for example, is litigated, is that a time when the parent now can, after stipulating to unfitness, can, say, well, I have a right to tell you more. There's no case says that. And in fact, the cases, discourage that from, adoption of Willow, adoption of Helen, the idea that a parent who has had their parental rights terminated, a huge event in anyone's life, a solemn event, an event of the utmost significance, can't be taken away. The judge was right in looking towards the cases where you have to look to the colloquy. Is there any problem with the colloquy? No. Uncontested to this day, there's no problem with the colloquy. The judge, in fairness to this judge, he did give them a chance, Your Honor, Judge Massing. So he didn't shut anyone down. He gave both an opportunity to argue, to proffer, to file an affidavit, to do anything. And they didn't do that. They just said it's too old.
Attorney Weber said that at the hearing on the motion to withdraw, they tried to proffer evidence, and the judge said, "I don't want to hear it."
No, that's not. I urge this court to look at the transcript of the hearing. He didn't say that. In fact, the father gave the father the floor to bring out what he would attempt to show by evidence, and the judge wanted that. And he brought up the idea that a witness was threatened by DCF, and the judge quickly considered it and found it to be without merit.
Counsel, what if the judge, back when the stipulation was entered, had said, okay, this is the trial, you guys are stipulating to all this evidence, and did a colloquy like he did, and then said, okay, the evidence is now closed. Sort of like a trial, but it was all basically stipulated, and then didn't issue any findings for 13 months. Would that be okay, or wouldn't our court say, well, if he didn't make a judgment and findings for 13 months, that evidence is stale? Because that's kind of what happened here. I know you want to get away from the time limit, and I appreciate that, and the stipulation is the stipulation, but it's the same scenario. A trial is held, but the judge doesn't make any findings for 13 months. What would our court say in that situation?
Well, I think I don't agree with that in this sense. I think the agreement was presented to the court, colloquy was conducted, and at that point, the judge accepted the agreement. And that, under adoption of John and adoption of Nate, that is the significant moment that triggers everything. To say that what happens here is 10 months later, he enters the finding of unfitness, and that my brother made a point of it, and this hasn't been addressed at oral argument. It's an interesting point. My brother talks about it in his brief. It's kind of a ministerial act at that point. The judge is quite open about it. The judge is open about everything he does, and everything he does is quite laudable, and according to the cases that this court and the SJC give to him. And he says, oh, I didn't make the clerk says you have to make a finding of unfitness. He's like, well, they agreed, they agreed to it, and I held off on the decree so they could participate in the hearing. And the clerk says, well, can we just make the finding now and enter it in? And he enters it in. I mean, again, when it comes to transparency and consideration and knowledge of the law, I think you can't credit this judge.
Is there any requirement or settled practice that the decree has to be entered like in open court, or can the judge do it in chambers and?
Not that I'm aware of at all. I mean, it seems I am unaware of it, Your Honor. I don't want to make any representations to this court. It seems like a judge could take something under advisement and issue, and issue or deny a motion, allow a motion. I don't see any difference. But again, I don't want to, I can't speak authoritatively to that. I see that my time has expired, and I apologize to this court for running over.
Thank you.
Thank you.
Good morning. May it please the court, Matthew Price on behalf of the children. This is not a case that I would characterize as dealing with a change of circumstance. It's a case that is dealing with a valid waiver. There was no contention that the valid waiver was defective in any way. There was no contention at the trial court that it was defective. There's no contention in the arguments in this court that it was defective. The parents entered into an agreement voluntarily and knowingly, and that's not been challenged. And that, when the motion was brought in the lower court to withdraw their waiver, what the judge's responsibility was to examine whether it was defective or not. And it wasn't defective. It wasn't argued that it was defective. It was only argued that time had passed. There's no indication, despite time passing, that there was any legitimate change in circumstance.
But that doesn't matter according to your argument. Even if there had been a drastic change of circumstances, we should only look at the stipulation in the agreement and whether it was a proper colloquy, correct?
Yes, because there were avenues to present evidence. With their motion, they could have provided affidavits. They could have provided certificates of completion of programs. They could have presented evidence a number of different ways to show that they weren't just dissatisfied or had a change of heart with their earlier decision, but that there was some substantial change that they wanted to put on record in evidence before the court, and they didn't do that.
I guess I'm missing it. How are they supposed to present evidence? You present evidence at a trial. You could support your motion with affidavits maybe, but the judge denied them, I think based on the transcript, the right to have a trial. He said no.
He denied, well, if I understand the question, he denied the trial, rightly so, but as far as the parents trying to give weight to their motion that they should be given an evidentiary hearing regarding change of circumstance, that would have been the vehicle to do it, and they didn't do that. There's nothing in the record to this day what their change of circumstance is that makes them fit parents.
But their argument is, it's not our legal responsibility to muster all of the evidence and bring it forward in support of our request to be able to present evidence. It should be enough that we say that, it's not, the evidence upon which you relied is now stale, and we want to withdraw our agreements because our circumstances have changed. I don't dispute that it would have been it would have made for a much stronger presentation if there had been affidavits attached, and certificates of completion and all the things you mentioned. But was that required in order to seek an opportunity to present evidence?
Well, I agree. It would have bolstered the argument. Without that, just a statement on the papers that there's a change of circumstance, I don't think that the judge erred in denying just based on that. Because there's no defect in the waiver, which is the primary issue. If the judge had allowed the withdrawal of the waiver without any sort of defect shown, according to Nate, that would have been an error. So I think that the judge was on solid ground in terms of what he decided as far as that goes.
What if, I always dislike giving hypotheticals, but I do it all the time. What if instead of the motion they presented, they said, we want to present additional evidence. We agree that the agreement and the stipulation is valid, and you can consider that up until the date it was entered, but we now want to have additional evidence. Would that have been okay? What would have been wrong with that?
I think the judge still would have had the deference to make the decision the way he did. The waiver and the stipulation were in, and it was solid. And to challenge that, you need to challenge whether it was voluntary or knowing. You know, without that, there's no question, I think, as far as whether the judge erred or not.
What about the staleness argument?
The staleness, well, in the context of change of circumstance, not as far as dealing with a waiver scenario. Rona was over a 4-year period, and it dealt with a trial, and it dealt with evidence that went into the trial, and it dealt with the judge not acknowledging the positive evidence that came in, only the sort of negative evidence previous to that. That's where, you know, that was stale evidence. That was a scenario of stale evidence over a much longer period of time where there was a contested issue, unlike in our case here. So where, in considering a change of circumstance, I would say a time, you know, that case gives 4 years.
Counsel, you're shifting it, and you're doing a very good job of it. But according to the statute, the decision by the judge has to be made, I don't want to say contemporaneously, but it can't be stale. So he makes a decision 13 months after the evidence is closed. Isn't that stale?
I would say there's no evidence to point that it is stale. There's no evidence of change of circumstances, and it's not stale. And the case law that deals with change of circumstance, where there is stale evidence, is much longer.
Again, you keep saying change of circumstance. Take that out of the equation, okay? The evidence is presented by the department 13 months before the judge makes the finding. And he doesn't talk about anything because there isn't anything presented to him. It's still the department's burden. Isn't that stale?
I would argue no. The evidence that was the exhibits in front of the judge was clear and convincing, and that supported the decision of unfitness and termination.
Okay.
I see my time is short. I can answer other questions if you like.
I think we got it. So thank all 4 of you. I mean, this is extremely well argued. You give us a lot to think about. Case is submitted, and we're in recess for this afternoon.
All rise.